practice. But other than that, everything I think that she said is correct. Please don't hold me to too high a standard. Let's have lowered expectations here. A word about what I'm going to be doing today. This is a course, these are actually two courses that I taught to lawyers about how to draft wills and how to do probates in Idaho. Now, but it's not going to be very different than what you need to know about wills, because we're going to go over everything that wills involve in estate planning, which is a little more than just wills. And so I'm going to go over that. Let me say that if you don't understand something I say, I like to speak in plain English, but if you don't understand a word I use, let me know, raise your hand, or I guess put a chat out. If somebody's watching the chats, let me know what the chat is. Let's see else. What else was I going to say? If you have any questions at any time, feel free to interrupt. I'm okay with that. Because if I make you wait, sometimes you forget the question. So let's strike while the iron hot. Is everybody okay with that? And Terry, you're okay.
Just have one question. Can the people on Zoom see the screen?
Yes.
Everybody good?
Yes. Yes, we can see it.
Yes.
Okay.
All right.
Yeah.
Well, let's go. This is we have some discussion here. Let's go to the next screen then, please, Terry.
Oops.
Terry, you just use the arrow keys.
On mine, that's what it is on mine, but I couldn't find an arrow key on here.
You have arrow keys?
Nope. That's all right. Just keep going.
Enter might work.
So it didn't advance.
Oh, it didn't advance.
No.
Well, that's no good.
It's hard to find good IT people these
Yeah.
days.
Should be doing this.
Well, if you want to send me the PowerPoint, I could share my screen. I could forward it. For you.
Oh, maybe this isn't.
These are the arrow keys. Just use, you should be able, okay, just do the num lock and you should be able to.
Hey Gail, I think he's in the presentation speaker mode and it's not, so there's probably another tab open.
Can you come up and show it?
Oh, yeah, you probably know better.
Why I don't like it.
Let's see, you're here. And
On my computer at home, it was real easy. I just put on the arrow and
we need
to
to
the next
be
screen.
here.
Yeah, well, the arrows are just on different keys here, but
And let's
but
do
it still
this.
didn't seem to
I'm
work.
gonna stop sharing for a minute. And we want to share. Let's share the screen.
It was no handout.
Now it's
No.
interesting. It's still.
It was all a PowerPoint.
Okay.
I thought about printing it out, but it's kind of long.
For some reason you are.
There you go.
This is the screen you
And
want
then
to
the
be
online
on.
version will get it. No,
There you go.
There we go.
Okay.
There we got the arrows.
Oh, those arrows, okay.
Okay.
all right.
Good.
Well, we'll see what goes
Do you
on.
want me?
All
I
right.
can do this.
Let's
Terry,
go to the.
you want me to do it?
Okay, sure.
Let's go to the next screen then. So the vehicle means just what kind of document you're going to be working on. You're printing. So
Now it's displaying the PowerPoint screen, so it's not another.
It's not showing this.
No, it's
Okay. Let's see. Yeah, you just can't get good help here.
I see a gray banner across the top that has a from beginning button. I think that's how you start the slideshow.
All right, what are you seeing now, Todd?
same thing. Yeah.
It's
Now.
I see one.
Well,
So shows the next
Oh,
slide,
yeah, it's like in presentation mode,
but
so
I've seen the first slide. Next slide needs
these are on the wrong screen, maybe, I'm not sure.
Isn't there go to the slideshow up above there?
Well,
Slideshow where?
I think you shared the
So you
wrong
see what's
window.
underlined slideshow? Click on that.
What we
Slideshow
saw was the presenter's
Underlined with pink.
version.
underlined
So-
with pink. Right here?
Yes.
Yeah, that's where we are. So we're right here. So
Beginning.
yeah. So let me get out of presentation mode.
Or change the display settings.
How about now?
Yes.
that looks good.
Okay,
Yes,
good.
yes, right there. You're going.
Yes, that looks great.
Now we're 10 minutes into it. All right. So the first question is, are we going to use a will or a trust? And let's talk about the difference between them. The will is a written document. Usually it's a physical document, although there's some online stuff going on, but for reasons of doing probate, these days you probably still have to have a written hard copy. Trusts are a different subject, and I'm not going to talk a lot about them, except down here at the bottom, their testamentary trusts, etc. Those are not filed anywhere, so usually not filed. There is a way to file them, but the public won't have access to those. So in estate planning, I prefer wills simply because it's there's a process that it goes through, a legal process that it's filed, and as genealogists, those become available to us sooner or later. We can actually get a copy of a will. A trust, who knows? It's in the hands of the trustee. And good luck finding one if you ever run into that. All right, so let's talk about different kinds of estate management in Idaho. And I'm going to say, so this whole subject goes back to Blackstone. What's that, the 1200s in England? And it's basically unchanged. Wills, we've had wills forever. I think the two biggest changes we've had is that women are no longer chattels and can inherit. Those uppity women, now they can participate. My gosh, half my law school class is women. And there are a lot of them are judges now. So, you know, that equality is gone, that inequality.
I'm getting there in about a minute and a half.
Would you please mute your speaker, whoever just spoke? Thank you. Everybody, mute your speaker. I'm speaking. Let's see. So, however, in Idaho, if your estate is under $100,000 and there's no personal, real estate involved, real property is the same thing as real estate. Then we can do it by an affidavit of small estate, and there's a form you fill out, and it just transfers everything to the person who inherits. Some other advanced directives are the living will and durable power of attorney for healthcare. Those provide for what's going to happen with you in medical situations. However, and they don't get filed usually, but if you get a copy of them, then sometimes they have names on and relationships. So if you run into one of those, that might be helpful for genealogical purposes, but they're not filed legally. General power of attorney or springing general powers of attorney can also be filed sometimes. Those are used in real estate matters and some other kinds of matters. Again, they would name the attorney in fact, but doesn't really tell the relationship. So it can be a relative or maybe not, somebody they trusted to do that job. And then trusts. So testamentary trusts are trusts that are set up in the will. And I often did this for two reasons: for minors, because minors can't inherit in Idaho if you're under 18. You either have to have a guardianship or a trust. And so I set up a trust in those. And the other type of trust I would set up is for a disabled person. It's called a special needs trust. And that would qualify that person for Medicaid purposes and other types of federal projects. So special needs trust. You know, somebody that has a disability, a severe disability, and they're gonna inherit something, they need to have a special needs trust, so it preserves their ability to have Medicaid. And then there are the regular common trusts, and some mean irrevocable trusts and revocable and irrevocable. Revocable is irrevocable can be for very, very large estates usually, and if you don't want to manage your own affairs, you want to have a trustee and just get a check or whatever, spend your money and you don't need to work. Irrevocable trusts are good for that. The revocable trusts, or otherwise known as inter vivos trusts or marital trusts or California trusts, they're the popular thing you see. You get the orange flyer today in the newspaper or in the mail. They're popular because they come out of California, because in California, probate is done on a percentage basis as opposed to Idaho, where we do it hourly here. And the percent is usually between 8 and 12%. Well, if you have $1 million estate, the attorney gets $100 grand right off the top. That's why everybody has trusts in California. I think the most I ever charged was like $7,000 for a probate in Idaho, and it's usually my base fee was $1,700 to do a probate. And then you say trusts take forever. Get our probate takes forever. Get our trust. My record on getting letters testamentary in a probate was 24 hours. Doesn't take forever. You get somebody who knows what they're doing and they're good at it. They can do it fast, and it can be very reasonably priced. That's less than usually the revocable trust, the marital trust, or whatever the newer trust costs. So anyway, that's my personal preference. I'm usually always right about that, but there are some times where trusts work otherwise. All right, let's go to the next screen. This is what I use when I gather information. Go ahead to that list. So in Idaho, and this is also true in most states, because Idaho is part of the Uniform Probate. We use the Uniform Probate Code. And this has been around a long time. And I don't know if I'm going to mention this on my PowerPoint, but the difference between the states in the West and the states in the East, and this is something that you're all going to hear and talk about, is the difference between an executor and a personal representative. In the Eastern United States, it's an executor, and old school is executor. In the West, the new word is personal representative. And that's somebody who carries out the intents, gathers your estate, and distributes it. That's the duties of the personal representative. We'll get to that. But in order to do a will, you have to be 18 years of age and of sound mind. Now that's often debated, but it's a very low standard. The standard in Idaho is, Rawl v. Rawl is the case. And Mr. Rawl was 92 years old, was blind and deaf, but a former businessman who had a strong mind. And the two people who witnessed his will were friends of his and inherited everything in it. But he knew what he wanted, and he knew he wanted to go to them. And that was upheld. The standard for testamentary capacity in Idaho is one of the lowest there is. You have to know what you have and who you want it to go to. You don't have to know the president. You don't have to know the date. Nothing. You have to know what you have. I have a house in Eagle, and I want it to go to my great-grandson, Ebenezer. That's all you have to do in Idaho. So it's a very low standard. Let's talk about holographic wills. Anybody know what a holographic will is? I want to guess. Yes, handwritten. And it has to be in the testator. Testator being the person drafting, writing the will, has to be in their handwriting. Can't be in anybody else's. It's got to be in your own handwriting, and it has to be signed. And Scanlin's laws, it has to be dated because because they do it several times, they rewrite it. There's several of them on napkins, whatever. I want to know what the last one was. So it can be written. I don't recommend it at all. Get an attorney or get a good form and do it yourself. Then there's the statute. There's the solemnized will, and that is section 15.2 502, in Idaho. A solemnized will is one that is actually in writing. In the old days, you probably all remember this. When we had them in writing and you wanted copies, you had to put copying paper, right, in between. What's that called? Carbon paper. Yes, you had a carbon copy, and every time you made a mistake, you had to go back and change it on all the pages. Oh, it was awful. Thank God for computers. But solemnized is a will that is in writing on a typewriter or a computer now. Computerized wills, I mean, all my wills were on a computer, but I printed them out, and they still do. So you have a hard copy. Signed by the testator, the person, y'all know what that is, writing the will. And there's one other word that's used for testator, and it's the female version, which is testatrix, which always sounds very tricksy. And most attorneys do not use that word. It just sounds kind of, I don't know, silly to me. So everybody calls them the testator. And two other persons have to be witnesses. They have to be over 18 and of sound mind themselves. And in Idaho, those signatures all have to be notarized in a will. And that's pretty common throughout the country. So, yes.
But Steve, on your first bullet up there, isn't that the reason why a lot of old wills are written? I gives his name, being of sound mind and body, or weak body, but he's letting everybody know that his mind is good to write that will.
That's correct. That's correct. But we're all clarified that. And what is a sound mind? You have to have capacity to do that, and it's a very low standard. Who you are and what you want to do. Oh, what you have to. You don't even have to know who you are. It's a very low standard, and I have had one will in my entire career challenged, and it was thrown out on summary judgment because I wrote the will and I did the probate. So just that this is a valid will. It's very hard to disprove that somebody doesn't have the capacity. And I won't go into too much detail about. I did have one case where it was a person that had a caregiver, and this is not unusual. And the caregiver got in and had them rewrite their will and name themselves as the beneficiary. That is a tricky situation because the accountant advised the person to go to do it and to change it. And in Idaho, that is a reason why you can't prove duress. If some other professional accountant recommended you change your will and put this person in, that's not under duress. And I was ugly because it was about $1 million estate. The family, I represent one of the 13 nieces and nephews. They got nothing. The caregiver got everything. It was very ugly case, very ugly situation. That's why I like wills and follow the process. Witnesses must witness the signing. There is a provision. This is arcane things are coming to me here. Where if they saw it at the time it happened, but they forgot to sign at the time, it can be done afterwards. They can sign and say they witnessed it afterwards. So, but they have to be there at the time it was signed. Okay, let's go to the next slide. Self-proven will. It's language that's in the code. This is common throughout the United States. And it says that it's a statement that in Idaho is before the person's signature that says I'm of sound mind and this is my will. Basically, there's specific language. And there's language also before the witnesses that this person appeared before us was over 18 and of sound mind. That's called self-proven. And when that happens, it's magic because you don't have to have a trial. You don't even have to go to court. This is a self-proven will. It proves itself. And it becomes part of the court process, and it's on file. It gets a case number. It can be researched. You can find it if you're good at doing research. The Idaho Stars is where they're kept in Idaho. But anyway, the notary public has to do both of those, all three of those signatures, the testator and it has to be two witnesses in Idaho. Okay, let's go to the next one. Nobody a witness. I think I said this. Anyone over 18 years old generally can't be a witness, maybe asked. What competent as a witness is I never had to challenge that. I never had to research it. Everybody was over 18, looked good to me. All right, let's go to the next one. All right, big wells. Sometimes this happens and ooh, you'll get an old will. This is how you revoke it. It has to be burned, torn, canceled, obliterated, or destroyed. And I had to do this and just I write cancel in Sharpie on the top of it. Or I shred them and whatever. So if you have a will that here's the problem, you have two wills. And one doesn't appear to have been revoked, but there's a second will that's newer than the first one. That generally controls, and in wills that I drafted, I put this will cancels any other previous wills I may have done. And that is another way of canceling or revoking a will. So
do you find that a lot in genealogical research where you go to microfilm and you find a will? What if there's a second will even back then, or was it done at the time of probate or the legal part?
You just hope that they're both signed and you know what the most recent one was. And that was the most valid one. But yeah, that's not uncommon. That happens. And it sends shivers down my spine, and got two wills out there. Which is the valid one? And was the previous one revoked, or which one was probated? That's the final.
And did you stop in your research after finding one when there might be two?
Yeah, another good point. There might be two. So make sure your research covers that person and all the different names they have used too. That's another thing. People change their names. They go by nicknames. They have middle initials. They have middle names. All of those things can change from will to will. So, and from probate to probate. All right, let's go to the next one. Does tangible property have to be listed in Idaho? This is one of the cool things about Idaho practice. In some states, they do list it, and I've had some clients ask that tangible property be in the will. My emerald ring be given to my niece Suzanne. In Idaho, that doesn't have to be in the will. It can be on a separate piece of paper. It can only be tangible property, however. It can't be cash, can't be notes, can't be deeds, can't be anything that's on paper. It has to be physically tangible. Desk, jewelry, furniture, paintings, etc. And other than money evidence, etc. And I always tell them to keep that with the will. And if it's done that way, it has to be signed. And my rule is that it has to be dated because that can change a lot. You get mad at your cousin or your nephew, George, you want to give the rifle to somebody else, scratch it out, change it, and sign and date it again. So that's a tangible property list. And that way you don't have to change the will every time you want to do something, change something, which is a really neat thing in Idaho. Not every state has that. So you're getting, if you're doing your own estate, this is your own course too on how to do your own estate planning. But we have that in Idaho, and it's pretty cool. And it makes wills a lot cleaner that you're not doing all kinds of detail stuff. Now, if it's cash, any of the other things, that has to be in the will itself. And I don't know, I'm probably going to get to this, but let me do it right now. There are two types of people that inherit in a will. There are heirs, which is what we genealogists are really interested in. That's the direct descent. These people would take children, or if you're not married, nieces and nephews, and people that go in a straight line down. Anybody else that inherits in a will is a beneficiary. And everybody in a trust is a beneficiary. There are no heirs in a trust. They're all beneficiaries. You have a trustee and a beneficiary. But in wills, you have heirs and beneficiaries. Now, in wills, sometimes everyone is referred to as a beneficiary and not identified as heirs. But at the beginning of all the wills I drafted, and a lot of drills, you have the names of the heirs and the beneficiaries and what their relationship is to the testator, to the person making the will. So, but that's the difference. You may find those two words, beneficiary and heir. That's the difference. All right, let's go to the next one. All right, let's go to disinheritance, no will clauses. One of my favorite subjects. So you have 4 kids and one of them, like, is a rotter, doesn't deserve to have anything. Do you have to give them a de minimis amount, 2 cents, $2, $10, whatever? No, you can specifically say this person, is my intent, this person takes nothing in this will. And I've done that and I've seen that in wills. Oh my gosh, the omitted spouse. This is a really tricky one. Because in Idaho, an omitted spouse takes as if they were married. And in the will. So that when I'm drafting wills, I want to make sure I know all the spouses and all the children. Oh, and this is really cool. It's not really, it is kind of genealogy wise. So I have a couple and they have previous marriages. I always say, and are there any children from a previous marriage or relationship? And boy, you want to make sure you're in a private setting when you ask that question, because if that pops up, you get looks at each other and things can happen. So I always make sure that I ask that question, because if there is a child that isn't listed in the will, and they're an actual biological child of that person, they take as if they were an equal child. All the others called pretermitted child. So anyway, that's got that on the bottom, pretermitted child, and its spouse. So this is why you do lawyers do this, so that lay people don't think about these kinds of things, but we lawyers have to think about stuff like that. Okay, let's go to the next one. It's kind of rare, but I had to come up. No contest clauses. I always put no contest clauses in my wills, and you will often see them in wills. However, there is provision in Idaho, a specific statute that says if probable cause exists for challenging a will, no contest clause will be ignored. However, to me, there was more value in putting them in because it deterred parties from bringing an action if they didn't have a case. And they said, grandma wanted to give me only 25,000. I was going to ask for 100, but if I do, I don't get anything by this, so I'm not going to challenge. I'm going to take the 25. So that's why I put them in, and it always worked in my case. But there are no contest clauses. But like I say, I put them in every one. Some lawyers say, "Oh, you can't do that." Well, I did it and it worked, and it deterred people from getting uppity. I had one case. Okay, I'll tell you about this case. I won't mention names. I can't remember their name anyway, so it wouldn't do any good. This was anybody know Michael Connolly's the Lincoln lawyer story? You know that? This was about a lawyer that had a Lincoln, and he had a brother who was a policeman in Los Angeles, and half brother, I guess it was. And so this is the half brother, and the half brother kind of went up through the ranks. And he writes about people in high level law enforcement positions. So I get this client, and his son actually, this is a way people often come to a lawyer. One of their children say, "My dad needs a will. Can we come in and do it?" And I say, "Fine, I'll do it. I'll do it. Your dad's the client, but you're welcome to come. And if your dad is okay with you sitting in on it, fine, we'll do that." So I talk to the dad and get the information I need to do the will. Dad comes in and I meet him and we start. I'm going to say, "Well, what did you do when we were working?" And he pulls out this huge gold badge, and he was chief of detectives of San Francisco. All the good lawyer stuff. My client. He hollered with my client. So anyway, there's a postscript to that. So I mentioned this earlier. He passed away, and I did the probate. There were 11 children, and he was living with the youngest son. And he was very insistent that everything he had went to the younger son, and he helped the younger son and his family buy a home with a father-in-law residence, and he lived in that until he passed away. So it made sense that the youngest son got everything, but I told the youngest son, make sure if there's something of sentimental value that you don't want, and somebody else in your family be allowed to their 11, 10, go ahead and give it to them, be generous about that. "Oh yeah," said, "I'm fine." Well, lo and behold, one of the other 10, of course, contested the will. And that's the one that went to court. And since the judge saw that I wrote the will on the probate, they dismissed on summary judgment, meaning the facts in the law are clear. this case goes away. And I won my plan. Actually, I had to hire another attorney or refer them to another attorney because I was a witness. I'd written a will, I did the probate. I couldn't contest of the will. So, you got a very good law firm to do that, and they got summary judgment. All right. I'm rambling on here. Let's go to the next, see what the next slide says. Okay, you'll find this interesting, I hope. Learning a little bit about wills and hope I'm trying to make this relate to genealogy and how, you know, if you run into this in your own family or some research you're doing, you got this background. And this goes back to Blackstone. I mean, wills haven't changed much since then, except some of the language, you know. We don't use the word party of the first part, party of the second part anymore, and some of that arcane language and the Latin phrases. When I was in law school, don't use Latin phrases, don't use party of the first, use plain English so everybody understands. So it can't be contested. Protective clause for minors and common person. We talked a little bit about this, but let's go to it. So testamentary trusts are created upon the death of the testator. So those don't come into being until the person dies. They're in the will, provided for, but they don't exist until the person dies. They can be set up in advance actually and funded, but usually even if they're set up, they get funded when the person dies. The personal representative, the executor, puts whatever is supposed to be in that trust. Same thing for incompetent persons. I said that, or beneficiaries with special needs. And that's a pretty common thing. I mean, there's a lot of disabled people out there, and in order, as I mentioned, to protect their Medicaid and other government programs, you need a special needs trust. And the way that works is that this money goes into the trust, and there's a trustee, and the special need, the disabled person is the beneficiary of that trust, as I said, trustee beneficiary. And it can only be used for certain purposes. There's some limitations on it, but it's pretty broad, and I was pretty good about doing that. The one thing, I mean, here's I can't give you legal advice, but let me give you what's the word I'm thinking of, a word of caution. A lot of people think, well, I want to avoid probate. I'm going to put my child's name on the house and give them the house early, right? That's a gift over, and it disqualifies them from Medicaid for 5 years. The person who owned the house is giving somebody a gift. So see a lawyer, get a special needs trust or some kind of a trust set up in that case. Minors trust, I mentioned, minors can't and shouldn't inherit. I mean, I don't know anybody, in the wills I drafted, anybody under 21 had a trust set up. And they got half of their 21 and half of their 25. There are spendthrift heirs and spouses and children you can set up trusts for. And also in Idaho, you can name a guardian or conservator. That's called a testimony appointment. And that person in Idaho has priority over everybody else, even the child, anybody, over everybody else in appointing a guardian or a conservator. And the judge, the decision the judge has to make is who is better for this person, the testamentary named guardian, or Joe Blow, who claims they're, you know, the person that should be. And that goes to court if it's questioned, but the naming of the guardian, the testamentary appointment, is the highest priority. All right, let's go to the next one.
Hey,
Yes.
so on guardians, let's say a man, a wife, and 2 kids, and the kids are 10 years old, and the man dies. Does the mother automatically become the guardian, or does the mother have to apply for guardianship if it's not appointed already?
Neither. She is the parent. She is the sole parent, and she has full custody of the child.
Okay.
So you don't have to do a guardianship in that case. However, in these cases, there are a lot of cases where that person is not capable of being the parent. There are drugs, alcohol.
I mean, is that a recent
in prison
change in the law? Because I ran into this in like 1880s, 1890s, where the man dies, different state, not in Idaho. Man dies, and then the mother has to apply for guardianship. for her own kids.
Well, we're getting into the old days of chattel, and
Yeah.
I see heads nodding where women didn't have the full
Right.
legal rights, and so they had to go through other processes to be named. It's sad. I mean, the law is not perfect, and we've done some terrible things under it, but hopefully we're in a new age and things are better now. But yes,
We have a case of a child who's considered an orphan early ages. His father was unnamed, died. We don't think the mother has died, but he's an orphan because his father has died. So we don't have any death information or what happened to the mother, but we're assuming the court deemed him an orphan because his father was dead.
that's a great example. And sometimes you may run into, though, on the good side, the naming of a guardian who happens to be the mother. And that would become clear that they're the natural mother of so and so. And then you have cases where the mother and father weren't married, and all kinds of strange things come out of that too. Well, let's see. So special provisions in wills. Yes.
At what age can a child choose their guardian?
That's a great question, and it's a guardianship question, but in Idaho, it's 14 years old. At least they get a say. Now, that doesn't mean that that absolutely is what's going to happen. But that's the point where that child has to be asked, who do you want as your guardian? Below that, they don't get asked. Or sometimes they do, but it doesn't carry as much weight as a 14-year-old. Great question, though, for guardianship purposes. And that's one of the areas that I practiced in a lot, and I did a lot of child guardianships. So you have to name the parties, and again, I mentioned, people go by different names. When I would draft a will, I would put their full legal name, and all previous names they went, AKA so-and-so, AKA so-and-so, go to 3 or 4 or 5 names. So that anywhere there's an old deed or a car or something that has a weird different name on it, named before they were married, all of those were covered in the will. So that's why I make sure all the names are in it. And if you have, this is not rocket science, and this is not new. Some really good attorneys in the past would do this. Others get a blow, that wasn't even their real name. So you'll run into that problem. Paying of expenses, tangible property lists, specific requests. When I drafted a will, I always put the specific request first. And then here's where you get the magic language. All the rest, residue, and remainder, which is legal for everything else, goes to that person or that organization, that beneficiary. So the rest, residue, and remainder of the estate. So the specific requests are first, and usually I would identify my child so-and-so, my child so-and-so, my friend so-and-so, my nephew. Anyway, kind of identify who that person is. So as a genealogist, we know why it's going to that person. Again, good estate planning attorneys do that, others not so much. We talked about, let's see. Oh, disclaimers. You can disclaim any heir, and any beneficiary can disclaim their share of the trust. And you might run into that as a legal document sometime. And that would generally identify the relationship of the person to the testator. So you may run into a disclaimer. There's a provision in Idaho and other states for common accident disaster. And the one in Idaho, the way it works is if you die within 48 hours of each other, it's 24 or 48. I always extended that out to a month. It's presumed that the person that wrote the will survived the other person, even if they didn't. So that will takes effect and not that other person's. So that's the common accident disaster language. Naming the personal representative and trustees of the trust that I talked about, the special needs and guardianship trust. So personal representative, again, the executor, everybody calls it the executor still. I know everybody calls it that, but that's where it's named in the will. And I also put in a bond, unless it's a very, very large estate, bond shall not be required. That's usually an expense that's not necessary in Idaho, but Again, you'll find that in some, if that's required, it's usually a larger will or there's gonna be a battle, and so whoever's gonna be. All right, let's go to the next one. Practical pointers. All right, devolution on death agreements. These are a form that in Idaho switches everything from the first to die to the second to die automatic. And it's agreement. It's an actual form that you fill out a document. It must be notarized and has to be recorded in every county where there's real property or where the person is located, where they either reside or are domiciled. And has to be in each property where real property is. Transfers everything automatically upon the death. You don't even have to do a probate. Boom. And that gets filed if there's ever any question. Oh, but that has to be filed in advance of everybody dying. So when they die, boom, that's there and pops up. As far as I know, the only place those are ever picked up on is title companies. And they look for those and they pick those up. And that goes on the deed, goes against the deed. So when that's filed, and you have a legal description of the property involved, and of course the county where it's located.
So is that what's called the community property with right of survival?
Yeah, that can be the same thing. It's a very similar thing. Mm-hmm. Yes. All right. Let's see here. Let's go to the next one and see how close we're getting to the end. I signed well. We talked about self-proven languages. And so I'm going to test her, the tester's name by some other person. 2 witnesses required, notary. Nothing new there, right? Okay, next one.
Well, notary plus. Oh, okay.
And now the way I often did it, and this is pretty common, although larger offices don't do this. But I would have 2 witnesses to the will, and I would be the notary. So I draft the will and be the notary. You can do that. You're acting in a different capacity as the lawyer, but you're a notary. You're a notary. I made copy. I always kept a copy in my file. I gave one to the original to the testator, and recommended they give one to the personal representative and the alternates. And the original should be kept in a safe place. So where do you find wills? You find them in all kinds of places. Mason jars and refrigerator freezers. The one I recommended is I have on mine. I have in a manila file in the regular desk with a drawer in the middle. It's right on top of everything, and I just pulled it out yesterday. I needed to check. So pulled it out, got checked, put it back in. So that's what and it's going to be the first thing that personal representative finds if they go to my desk. But put it with the bills, the original with the bills, or some other important papers that's going to be easy to find. Do not ever put the original of a will in a safe deposit box. God forbid. It's a catch-22 because you can't do probate without the original of the will. You can't get the original will and get it in the safe deposit box unless you got letters testamentary. Don't put it in the safe deposit box. Put a copy in there if you want, but put it in a safe place where it can be found. And if you have a safe at home, I guess somebody else knows it.
Yeah, I was just thinking, fireproof it.
Fireproof.
You put it in your desk and you have a fire and it's gone.
I got originals all over. I got copies all over the place, and my PR has copies. So, and in Idaho, we have what's called the best evidence rule, which means that if you can't have the original, if you have a photocopy, that would stand in its place. You have to give an affidavit that the witnesses actually witnessed it, but it can be used as the original in place of the original. All right, let's go to the next one. Safe place. I think that's the end. All right, can we bring up the probate? Let's go to probate. Do you have any questions, anybody online or unmute, speak up, or anybody here? Everything you wanted to know? Yes, sir.
If you challenge a holographic will, when the witnesses are dead, by saying that it's not. Should I exit screen share before going to the other presentation?
Yeah, you can.
Well,
I'm not quite sure where the other presentation is.
Let me hand out this. Oh, what the heck happened there?
Well,
So if you want to stop share there. And let's look for, are they down under PowerPoint? Is that where they are?
No, I don't think so.
Okay.
Let me see if I can minimize this.
I'm gonna do this because we're still in the slideshow.
we can go back on.
Click to exit.
It's not to coming to win the able.
Let's close out here.
Yep.
And I think it's this one right here. So that's the one I wanted. So should I go slideshow first and then share, or share
Is
slideshow?
this what he wants?
Yeah.
Okay,
No.
yeah. I don't think you can slideshow it yet, so go
Okay.
back to Zoom and share.
Secretary of State, and then revise it.
I don't think that's it, is it?
But is that what's going to be
Share down
created
here.
for now?
Which one of these do I pick?
That's what I want to
I
recommend.
think if you pick your entire screen, it should be fine, and then share, and then we'll go to
Or whoever,
the
some
PowerPoint
places it's like, oh,
and start the share, which is
Some other
slideshow
place.
there. And
I had a question, Steve.
Yes.
Would you explain again on accident and disaster part?
Yeah.
Would you explain that again? I did you say 24 or 48 hours minimum?
Is there a way for me to put this on my lap so I can actually see the, or will it fall?
Yeah, I don't see why not.
How much space do I have?
Just take it over.
Okay. Perfect, yeah.
Probate is presumed to have survived the other person. And now the other persons can be also filed, if they have that language, they're presumed to survive the other one, but each will has its own effects. And if there's different results, then it goes according to the results in that will.
Is it in presenter mode?
Not very.
It's not in slideshow mode. I thought it was.
Is that better, Todd?
Okay. All right.
Yep.
Talk about probates here. So we talked about wills, that's person's alive, you know, this is estate planning, you're planning for somebody to die, yourself, you're the testator. So the person dies, go into probate. Probate is a legal process in Idaho and in all other states, as far as I know. It's a legal process where a will, or if it's intestate, we'll go into that in a second. Where the person's estate is processed through a court process. That's probate. There are two kinds of probate. There's intestacy and testacy. Intestacy is where you don't have a will, and testacy is where you do have a will. And in Idaho, it's the same process. Everything is identical, except you don't have a will involved, and they both have a personal representative. So that's the difference, but otherwise the process is the same. So in Idaho, you have a small estate, and that's well, let's talk about what's not in wills and estates in Idaho. Non-probate assets, IRAs, SEPs, 401ks, pension plans, life insurance trusts, annuities. None of those are part of the estate process. And they almost all have a beneficiary name. You get a card and you name the beneficiary. Almost every one of those has that. And that's totally out of probate. Those never go through probate. Now, a lot of times the personal representative, the executor, handles that, but that's not part of their duties or their job. And the heir or the beneficiary has to contact the company that has the plan and distribute it, and they distribute it directly to the beneficiary. So let's see. And then you have the devolution on death or community property agreements that you talked about, where it all goes to the other person on the death of the first one, and those are already recorded. So again, that's not part of the probate process. Although I always attached a copy if I had one, just to show that there was such a thing out there. Small estates, and I talked about this. If it's under 100,000 and there's no real estate, you don't have to do probate in Idaho. You do an affidavit and it says, so and so died on such and such a date, and their estate is under $100,000, and I am the beneficiary of that estate. Give me the money, and you sign it in front of a notary, and it's written in the proper form. Banks, everybody has to, under Idaho law, has to observe that. So you don't have to do a probate estate under 100,000. And that's really a good thing, particularly when I started out, because there would be like, when back in the old days, when homes in Boise were under $100,000 over a lot of them, you know. I bought one here for 28,000 one time. You don't have to do a probate in that case. You know, I think that should be raised now to about 500,000, but it's 100,000 now. Affidavit, small estate, and talk about devolution on death. Let's see here. I have an example of affidavit at the end of this presentation if y'all want to see one. And it can't be filed 30 days before 30 days after the person died. You have to wait 30 days after they die. Nothing's filed with the court. And go ahead to the next slide, please. Let's see here. You can read this as well as I can. Can you see it? Is it way too small? Well, let me see if there's anything I think that's. These are affidavits, a good method for settling small estates, and one should always consider using this vehicle in administrating and settling small estates. So a lot of lawyers, just to make money, will not do that, or either don't know about it. Newbies don't know there's such a thing. And there are some lawyers, you know, 95% of all lawyers give the rest of us a bad name. Get that joke?
That's what you say.
You got that, yes. I said that. So they will go ahead and do a probate on a small estate when they don't have to. If there's no real estate. If there's real estate, you got to do a probate in most counties. There are a few exceptions. I'll probably get into that. And you can use an affidavit of non-probate, and I have that affidavit attached. That is not good in Ada County for real estate, and there are like 5 counties in Idaho that will not accept those. So if you're an attorney doing the probate, call the county clerk or the assessor and see if they accept affidavits in non-probate. But if they don't, we got to do a probate. Sorry.
Is that? So if you have a house, you're required to go through probate even if you've got a trust and you said what you wanted?
No, if it's in a trust, you don't, because you don't own it.
Well, yeah, that's true. Well, you do.
We do after the trustees as well.
Well, you know, when I went to law school, if you did that in law school, the trust collapsed. The trustee and the beneficiary are the same, collapsing. Nowadays, with the California trust,
Well,
courts ignore that.
yeah, well, anyway.
And besides that, if you're both dead, there's no trustee. Now you name successor trustees I've taken. I don't know.
We do.
Depends on what's in the trust.
No,
Some
we
trusts,
don't.
some trusts didn't do that. Well, you're in a mess. $20,000 to settle that mess.
It's all
Or
it's all-
You
it's all-
hope. Good luck. Because when I get a call on those, I say, I don't do those. All right. Let's see here. And I said those documents can be used to deal with bank savings and loan, credit union savings accounts, deposit boxes, brokerage accounts, in some cases, real property, using the affidavit in those counties that I mentioned. Let's see. The affidavit is also good in title chattels such as motor vehicles and real property. Motor vehicles, DMV actually has an affidavit to do that. So when somebody dies and they don't have a will, you haven't done a probate, you can do an affidavit of non-probate and sign it and say, I'm the heir, I get the car. And I use that a lot. That's a great one on small estates. All right, let's go to the next one. I did at the bottom, that last one I had the, can you go back just quickly? Using this document, some counties is currently not accepted. But Ada County and blah, blah, blah. So anyway, go ahead to the next one. We talked about the devolution on death agreement and community property agreement. So I'm gonna skip that unless anybody has questions. We've already transferred, person died. It was recorded by the in the county recorder, and the title company picked it up. And I never had a case where they didn't pick it up. Because there's a legal description. Somehow AI knows what every document has a legal description, and that's what a title company looks for. Let's see here. I talked about that. It's the way to transfer everything from the first to die to the survivor automatic. And it's filed with the county recorder. All right, let's regular state, informal versus formal. All right, let's go to the or supervised administration. Let's go to B there, but go to the next one. Informal probate, which was like 90 to 95% of my probates in Idaho. These are where it's gonna be uncontested, and there are no claims or against the estate that haven't been settled or will be settled. And so you file for informal probate, and you can do that by appointing a personal representative or a letters of administration where there is no will. It's a lot quicker and easier, of course, because there's no hearing held. So it's effective 14 days after the application is filed, unless there is an objection. And I don't think, I'm trying to think if I ever had an objection within 14 days. I don't think so. And the judges got so used to this that that's how I got my 24-hour letters. Was the judge said, this isn't going to be contested. I'll do the letters today. I'm going to get out of here by 5. So anyway, and that's how fast I got letters of administration if it's intested, and letters testamentary if there's a will. Informal probate has to wait 5 days after the death. And but you avoid the cost of publication and court appearances. You do not have to, and I don't know, every attorney thinks you have to do a publication to creditors. No, you do not. If the law says it may be published, it doesn't have to. And that's what is it, $150 now to publish that notice. And if you've got somebody who pays all their bills like me, you don't have any debts, why publish notice to creditors? And besides that, the death notice has appeared. And if you get the personal representative usually goes through all the bills and sees that there may be a debt, a medical bill or something out there, pay it. That was my advice to personal representatives, executive, pay the bill. And that does away with that claim. So anyway, a few of them think they're smarter than me. They you can contest them, I guess. Let's see. Most counties permit informal probates to be processed entirely by mail and no court appearance is necessary. So you won't see a court appearance in a lot of these, most of them. Less expensive than formal. The original of the will has to be filed with the court. Unless the court already has the original, and sometimes people send the original to court, but they just sit on it until the person dies, I guess. I thank God I've never had that happen. But, let's see here. There's no determination of the validity of the will, other than in the letters that just statement of pointing the order appointing the personal representative says that they have the original of the will, and it appears to be valid. First, of course, any probate are that challenges to the early distribution of assets, and this is a real issue among we probate attorneys, or when I was one. When do you hold out everything until everything is ready to be distributed and do it all at once at the end, or can you distribute it at any time? Well, it's legal to distribute at any time, but sometimes there were people that really needed some money, and I would go ahead and distribute it if somebody really needed their share. If they were okay with waiting, then we'd wait and do it all later, or maybe do it all at the end. And then I'd get a affidavit of saying that they'd received their share and they release the estate at the end. If there's a will contest, you can see it coming. Formal probates are considered and usually happen. And also lost wills. If you have a lost will that I had this happen a couple of times, where I had a copy of the will, but it wasn't signed. And that had to be done with formal probate. I put that in and said, yes, this was signed, got some affidavit saying they witnessed signing. Let's talk about formal probate. It's a legal proceeding. You have to file for a hearing, you file it and then ask for a hearing set up, and that determines whether the will is valid and who the heirs are. Notice that the hearing has to be filed. Let's go to the next slide. And then there's an order issued just like in the informal probate. And most of the times in formal hearings, and if you ever go to court and it's the probate hearing date, you'll hear these formal things that the judge will say, is anybody here to testify on behalf of this will? Nobody will stand up. He'll say, all right, I'm signing the letters. But sometimes there is a contest, and usually the judge of the court knows about that. Somebody has filed an objection, and they'll set it for a hearing at a later date. Usually during that date, all of those wills that came in, that there's a formal probate and a request for accepting the wills of the claim, nobody says anything. Judge signs it right there. But it's expensive. It was in my day at least $1,500 to $2,000. Notice everybody up at that hearing. You have to notice all the creditors, all the heirs, all the beneficiaries. File a notice, set it up, call the clerk, set a time up, etc. And also the filing suspends any informal probate that's going on. And if there's a personal representative, they have to stop doing everything until the final distribution or the final hearing has been held and it's decided whether it's a valid will or not. It's more expensive, more complex, takes longer, at least 45 days to allow for publication. I mean, you have to do public notice to creditors and to parties of interest. So it's a pain. And when I got toward the end, if I could see this coming, if I wanted to go on vacation, I'd just refer the case to some other attorney to do formal probates. Because there are firms that do a lot of this, and they're good at it and they do it. And I just like to do the informal one. Let's go to the next things. Special administration. It appoints a personal representative or special administrator, and it's what I used when it's been more than 3 years since the person died. I forgot to mention the statute of limitations on probate. It's 3 years. You have to file probate within 3 years after the person died. Now, if there's a couple, it's within 3 years after the second spouse died. First spouse could have died 20 years earlier. Doesn't matter. As long as you meet the 3-year deadline on the second surviving spouse, then you're okay. And that's where the special administration comes in. You do, instead of a appointment, you get the special administrator appointed, and then you do a determination of heirs. So that's where it's been more than 3 years, and we don't have a. What am I going to do? It's been 3 years. Do a special administration. All right, let's talk about summary administration. I didn't do these very often. Let's go to the next screen. Thank you. This is where it goes from the first to die to the survivor, where there can be no separate property. First of all, if there is, can't do special administration. And I never did this because it doesn't go through the probate process, and you don't get personal representative appointed who can handle the estate. It's just everything goes to the surviving spouse. If there's a claim against it, boy, you're back to square one. Then you have to initiate a probate all over again. So if there's going to be property that has to be transferred, I either do an affidavit non-probate or just go ahead with the probate and avoid this one. But A lot of attorneys like to use it because it's fast, it's easy, and I guess arguably a little cheaper. Let's go to the next slide. So, yeah, well, we're getting toward the end here. This is the affidavit small estate. This is what you use when it's under 100,000 right here. I've used this dozens and dozens of times, and it has to be notarized at the end. I don't know if I have the notary. Oh, the at the end is the person signing. So anyway, that's what it looks like. Anything under 100,000, whether it's real estate. 30 days to elapse. No application for probate for claiming personal representative pending, and the claiming successors entitled to payment or delivery of any indebtedness owed to the scene, any tangible personal property belonging to any instruments, evidence that debt, obligation, stock, or chosen action. Boy, that's a legal term. Chosen action belonging to the deceased. And then such indebtedness personal property include the following and listed, and then the person signed it. And that works like a charm. Banks hate this, to see these come in, and they always refer to their attorney, and attorney says, no, this is a valid form. The law provides for this. You have signed. Yes.
So this affidavit of small estate is actually a part of the probate process, right?
It is. It is a probate.
I mean, you're not avoiding probate, it's just part of the probate process.
Well, you are actually avoiding probate.
Okay.
It is an alternate to the probate process.
Okay.
But it is filed. No, they are not filed. There's not a caption on it. So, but it's small estate. You know, it's under 100,000, and usually there's no challenge to it. But you may, you're going through some of these papers, you may see this. And that's what it is if it's mentioned. All right, let's go to the next one. That's just a notary sign. This is the affidavit on probate I talked about, where in some counties, it's not a complicated case. You want everything to transfer from the person that died to the survivor without doing a probate. This is the form you use. But Ada County, and I think it's 3 or 4 other counties in the state, do not allow this. And but this works even when there's real estate. You list the real estate that's involved. Okay. All right. Okay, let's go to the next one. And just the rest of that form, the next form. Devolution agreement, community property agreement. We talked about that. This is what it looks like. It says, if you ever see one of these, this is for genealogical purposes. It says they were married, the date they were married on, that their husband and wife, and then lists any real property they had. And they both sign it. We go to the next page, and it has their signature. So you have the name of the husband, name of the wife, and it's notarized. So, all right, let's go to the next document. We're getting close to the end here. Like I said, it has to be filed. The probate has to be filed within 3 years, and so when does the personal representative determine how much things are worth? Usually, everybody agrees, that such and such is worth so and so. Then you get into real expensive jewelry or paintings or other things that are cars that are pretty valuable, like the Rolls I just bought, which is really pretty cheap actually. Old Rolls are really cheap. New ones are another story. And so you have to get an appraiser, and I like to go to auctioneers because they know who appraisers are, and so, or you can look them up on the internet, appraisers. Anyway, get them appraised, and then make sure you get a good appraiser, and I think they're certified. Yeah, and you get an affidavit if something has to be appraised. All right, let's go to the next one. Can we go back to that? I want to see what the heck is this document? Oh, okay, these are alternatives for probate. Okay, go ahead. We just the process. It's just talking about the process that goes through on a either affidavit of non-probate or the actual probate process itself. The PR has to do the personal representative inventory to stay within 3 months after their appointment. That is observed in the absence rather than the performance. Good luck, there you tell everywhere, good luck getting an estate inventory within 90 days after the person died. They never do it, and in cases where there's gonna be a battle in the family, change the locks immediately. I had people actually go in during the funeral, break into the house and take everything out of it during the funeral. Unbelievable. People are so crass and greedy. I mean, genealogists, you've heard bad stories. I've seen it happen, and it makes me so sad. And if that's ever going to be a problem, get those locks changed ASAP and make sure you know who has the key. All right, let's go to the next one. I hope this is relevant to genealogy, all these horror stories. Renunciation, nomination forms, we talked about replacing. Proving the original versus copy, I've talked about that. Lost wills have to be done, has to be determined by the court that the original cannot be found, the copy is valid. Let's get next page, challenging the will. Best to do formal, at least for filing purposes. Now you can file formally in Idaho and settle it informally. So if you think there's going to be a contest going on, and the parties get together Friday or over the weekend, and they get everything settled out, fine, we'll close this informally, and the personal representative will distribute as everybody agreed. And best to get that in writing if you can. But yeah, if they settle it, let's settle it informally. Don't have a hearing. But actually, it'd be a second hearing because you have the first hearing open formally. Second hearing closes formally, so we can close informally. And the termination or replacement personal representatives provided for. I've had some bad ones. I've had the PR steal money, a lot of money, $250,000 from the city. They get rid of that person. I've had conservators go to prison for things they stole. But generally, most personal representatives, if you get one that's doing their job right, you're good. But this is the thing I like wills over trust is the court has supervision over the personal representative and can remove that person at any time. And they have to file documents every now and then with the process that says that the estate is, and also closing documents and show that they're doing their job. And so there are ways to keep them on the job and remove them if you have to. All right, I think that's it. Let's try the next. Is there another one? Oh, this is the letter testamentary. This is what you get when you're the executor or the personal representative in Idaho. This is what you get. Not very long. Next one. That's the signature of the notary. Next one. Letters of administration. This is in intestacy. It's the same process. Very similar document. Again, signed by the judge, magistrate. Next one. Next. End of discussion. All right. Any questions or comments? For you survivors, thank you for being so patient. And you online, did anybody have any questions online? I didn't see any. Did you see any chats?
I was.
If you have anything, I guess, can we unmute yourself and say something?
And I give everybody my father's advice. All of my life, my father said, no matter how little you have, write a will. Because if you don't, when you die, your relatives will fight over it. He lived to be 93, and he died intestate.
Well, he was a very wise man. Even if he did, he died in intestate. Told everybody. Saying one thing and doing another, that's not true of us, we attorneys. All right, well, thank you very much, and thank you for watching, those of you online. And we'll see you at the next meeting or whatever.
All right, thanks everybody for coming.
Thanks, Steve.
You had a question, Lori?
To available to.
Nope, just telling him thank you.
Okay, all right.
So we have a couple of slots still for the introductory class, Tuesday, Thursday. So go on to the website if you want to sign up. There's a couple spots in person and there's definitely room online as well. So, and actually on Tuesday, we could talk about where to find probate records. So probate will be on probate and land records, DNA on Thursday, and AI and military records. So yeah, if you're interested, just go on our website and please sign up so we can send you links and we'll save you a spot in person.
Next month, we're gonna have Angie Davis from the archives here. Give us a talk on the available assets and resources that are here at the archives. And we may even take a tour. We may not, I don't know. I have to talk to her after this meeting to see how she wants to work the session, but it should be a very interesting session.
There's some cool things here that ordinary people don't get to see that they may show us.
Yeah. So, thanks everybody for coming, and we will see you next month. Appreciate it.
Yes.
Responding, one.
Steve, is there any way we can get copies of some of those flight documents to read?
To the A County Court Systems, Google it. And there's also, if you go in the courthouse and you go through straight ahead into where the clerks are, or the windows are.
Very good information.
You can go in there.
For those that